Good morning, good afternoon, good evening to all our audience. Thank you for joining us for this 5th episode in our webinar series on Investment Mediation Insights. Today, we are having with us Dyalá Paraguacuto-Mahéo, who is a partner at Foley Hoag, an experienced counsel in investment mediation and arbitration, and will share with us some practical insights on practice. On the policy level, we have two further speakers with us. We have Dyalá Jiménez, I hope I got that right today, a former foreign trade minister in Costa Rica and investment arbitration practitioner, as well as experience with negotiation of bilateral investment treaties. And we have André von Walter, who is leading a team in the DG Trade of the European Commission and working on investment dispute settlement matters. So before we start today, let me just briefly recall the initiatives that we have seen over the last months, if not years, on investment mediation. Starting with the good news, last time when we got together, I was talking about working paper 6 that we just published on the amendments, including the ICSID mediation rules. And later this month, we will be sending our rules to member states for a vote, with the hope that they will enter into force then in the summer of 2022 once adopted. Of course, parties are free and have in practice already done so to adopt the mediation rules as they currently stand and ask ICSID to administer the mediations. We have published background papers on model clause, on investment treaty provision on mediation, as well as a background paper, and Damon will put those links in the chat. So besides all of that activity, we had published a series of blogs and, of course, this webinar series where we want to feature practical insights from practitioners and policymakers who have worked on investment mediation. So more detailed biographical information on our speakers is available on our website. And for the format for today, what we'll be looking at, we'll have an informal chat and conversation between the four of us. If you have questions and like us to go deeper into any of these topics that we will be covering, please put that in the chat and I will pick it up at an appropriate time during our chat. If not, we'll do that at the end. So Dee, let me start with you right away. Let's jump into it. So over the years, as we have analyzed the mediation provisions in investment treaties, there's a trend from including mediation as an option, and there are different policy choices that states have made. Can you tell us a little bit about the Costa Rica, UAE, United Arab Emirates bilateral investment treaty that seems to have a mandatory provision for mediation as a prerequisite before investment arbitration could start?
Yes, Frauke, greetings everyone, and thanks to ICSID for inviting me, and congratulations on so much effort put into advancing this tool and introducing it to our world of investment dispute settlement. The bit, as you say, does include a mandatory provision. It was entered into in 2017, so it is a recent bit. It is a modern bit by all standards if you see the rest of the provisions. And what it does, it includes a mandatory submission, and it actually expresses that it is a mandatory and a condition precedent to arbitration. After consultations and direct negotiations, within 3 months of the notice of dispute, parties should submit the dispute to a third-party procedure, such as conciliation or mediation, before an authorized center of the party complained against in the dispute for a period of 6 months. So this, as you will note, it is a good multi-tiered clause because it has specific deadlines and procedures. It is really good in terms of interpretation of the clause for future disputes. However, sadly, this has not been tested in practice, so I cannot actually delve in more. I just want to add that this case is actually an outlier and does not necessarily reflect at least Costa Rica's policy or position on mediation. And actually, when we get into the policy discussion, but I just want to set the stage, Costa Rica does not have a policy on mediation for international cases. It has not even signed the Singapore Convention, which is notorious, given our country's reputation of neutrality and defendant of the rule of law. And I think actually the main reason is twofold. The first is that we have had good success with ISDS, with arbitration in general. So we haven't focused our attention on mediation. And the second is something related to the resources. The ministry in charge of that part of our policy was the ministry that I led, as you mentioned, and it has quite a small team, not many resources. And so I actually think it's a matter of just the time that you need to devote as a government to build a policy on this. So I think I can leave it with that. I just want to also set the stage for the following interventions.
Welcome.
And I think that when we see these clauses, we need to think in two terms: case by case, what it means for each specific case, and policy considerations. So we can delve into it later.
Yeah,
Frauke.
we'll get to that for sure. So thank you for pointing that out. And I think congratulations. I think the less investment disputes you need to somehow settle amicably or through arbitration, the better for the overall operations of projects or development of economy. And for explaining sort of the mandatory mediation provision as a condition precedent, starting with the notice of dispute, I think that is one thing to highlight here too, how broad that wording is, right? It's a notice of dispute. It's not a notice of intent to arbitrate. That the intent is, hey, we have a dispute, I put you on notice, and now let's find a way to solve it in different ways. So that is one way that we've seen in treaties, and thank you for that. And that is a perfect segue, Andre, to you and the work that you have been doing, or the EU has been doing, and negotiating in FTAs and mediation provisions. So what can you tell us a bit more about how mediation is envisioned in the recent FTAs?
Yes, thank you very much, Frauke, and thank you very much for ICSID to giving me the opportunity to participate in these discussions. Maybe I may start maybe a little bit with our policy considerations, why we've started to include detailed mediation rules in our treaties. And this is basically because we believe that mediation can constitute a very good alternative or supplement to classical litigation in the investment area, because it is arguably less time and cost intensive, which is good for states, but also good for investors, in particular for SMEs. We also think it may be better suited to maintain long-lasting relationships between investors and states, and by this also to retain investments in the host state in opposition to litigation, which sometimes is used as an exit strategy. Because normally, I mean, I believe personally an agreed solution is better than an imposed solution, because with an agreed solution, both sides are equally happy or unhappy and can continue to work together. And also potentially an agreed solution will lead to less litigation at the enforcement stage, which we also see quite often today in the field of classical ISDS and arbitration. But we have also seen that the recourse to mediation and ADR is not yet a usual reflex by investors, and so therefore we have decided to include specific provision in our investment treaties in order to show that there is an alternative and that is available, and to show also there are rules that can apply and how this would look like in practice. So in a nutshell, normally what we do in our recently concluded EU investment agreements, we have within the investment dispute settlement text a particular article on mediation, And then we have an annex with more detailed procedural rules on how to conduct the mediation. Normally in the text itself, we offer the possibility to mediation, and we say that normally the disputing party should give sympathetic consideration to any request for mediation that it receives. And then in the more detailed rules, we have then rules on how to appoint a mediator, which normally is appointed jointly by the disputing parties, but we also foresee the possibility to ask a third person, for example, to appoint a mediator from a list of individuals that have been agreed by the contracting parties in advance. We have rules, for example, on specific procedure, how to involve experts or stakeholders, on the timelines, for example, on confidentiality, on transparency also, which are, maybe we'll get back to this a little bit later, on how to terminate mediation procedures, how to implement it, and most importantly, also, we always have provisions saying that whatever is being said during mediation procedures should not be used in subsequent or parallel litigation or dispute settlement proceedings. And we think this is very important also to create a situation of trust where solutions can be explored and common grounds can be found. So I think I stop here for now. These are in general, in a nutshell, what we have in our recent text on this, which are all public.
Yeah, thank you. And picking up on that last point, the without prejudice provision we already have in the ICSID Convention in Article 35, sort of this overarching principle has been around for the settlement discussions, at least in the ICSID context for over 50 years now. And thank you, André, for guiding us through and looking at, okay, mediation is not only a possibility in the early stages, in the amicable settlement period, but from the practice that you drew, that it can be helpful for parts of it or the entire dispute alongside other and complement other mechanisms, and even at the enforcement stage or after an award has been rendered, which we have also seen negotiations of implementation aspects, for example. So you already pointed us to several aspects of government officials. What can government officials, or what should maybe they take into account from your experience and perspective when designing or including policies in investment instrument, be it on the domestic level or on the international level? What are your thoughts?
Well, I think the why to do it, why either to just insert a clause in a treaty or provision, or why develop a policy is very important. And André mentioned something that I think is interesting. He mentioned the need to provide opportunities for foreign investment not to leave the country. And a World Bank study ran by Roberto Echandi said, concluded that around 25% of FDI leaves countries quietly, and we don't even realize, or governments don't even realize. Only 7% actually invoke ISDS provisions. So I think this is a fantastic reason as to why governments should think seriously about both, including arbitration, mediation provisions, and developing policies around it. So that is why I divide the issue in two, in the provisions themselves, what it means. And I think André explained very well the great advantages of having good provisions, model provisions, and having the procedures well set out, and then the policy underlying. And I think the first challenge that government officials have is to understand something that seems quite obvious to us, that one thing is that governments are political entities which respond mostly to local interests, while their policies, especially in the realm of FDI and other international aspects, will affect their country's abilities in the long term, or middle term at least, in the international sphere. So I think one of the biggest challenges is to understand how to translate and communicate locally the need to provide for these mechanisms internationally. And the reason I say this is because we know that there are quite some studies that delve on the reasons why states are so reticent to enter into mediation. And I read the report on the GAR Live Dubai event in November of last year, where the sentiment appeared to be that states and state entities were taking undue advantage of these provisions, right? Either by prolonging the step to arbitration or using it as a tool to gather information. But I'm not sure that is actually the reason why states like these provisions or enter into these provisions in the treaties. And we will not know until we know what the policy behind each state is. However, I do think that states need to take into account several issues that have arisen from surveys like the 2017 Energy Charter Secretariat survey, and they analyzed the different aspects. And just to introduce and leave the floor to other questions, Frauke, I think the main findings of the reasons are reasonable. They showed that there was a lack of clear domestic legal framework as regards the authority that public officials have to settle. This is a huge concern for public officials. The second is that the other surveys that we have had, the UNCITRAL Working Group 3 also, is not only getting the framework right, but also overcoming psychological barriers of the government officials. And this has to do with the complexity also of the different multi-stakeholders within governments. And the third is how to create a synergy between arbitration and mediation. So I think those three challenges, coupled with the first that I mentioned, which is how to communicate and sell politically and locally the possibility to settle disputes internally. I think those are the main challenges that government officials face in developing a real policy. And of course, finally, for all of that, we need to get government officials educated in the process. But that is something I think in parallel, and it's huge. And I think that's where ICSID has done a good job and will do probably more, right?
Yeah, we certainly have delivered courses for government officials, have been working with the IFC to address mediation skills, negotiation skills in the context of preventative measures even, right? If we go back to the timeline, at one point, can these skills come into place? And certainly also part of representation once you're in a mediation. You had a couple of points, Eddie, gathering information. I think once we had in one of our webinars, Counsel for Investors, and Diana will maybe share later on a couple of points on that. It always is about strategy. How do you approach the negotiation, and how much information do you share? And from counsel who have participated, we've heard that there is a way of doing that on a balanced level, a state or investor on both sides. And we've also, you brought up the authority issue. That is what is so interesting about the model instrument from the Energy Charter Secretariat to address that aspect. And many states that we have seen have developed this lead agency aspect, so that you have at least a contact within the government that you can turn to. So thanks for setting out these different policy considerations. André, I would come back to you. What do you see as challenges to investment mediation, be it sort of on the policy level or on the implementation aspect, practical considerations? What are your thoughts there? What challenges are there, and how can these be addressed?
Yes, thank you, Frauke. On the practical challenges, it's a bit difficult for me to speak about this, since we have not yet received any request for mediation under EU agreements. Our practical experience is quite limited here. But this being said, I believe that one of the challenge I can imagine that can be quite interesting in the future is how to find the right balance between the necessary confidentiality of the mediation procedure, which I believe is essential in order to create a environment where parties can speak freely, explore solutions, and trust each other, but also the very important policy objective of ensuring transparency of investment dispute settlement, where often public interests are at stake and the taxpayers' money may pay in the end. And so here, what we have foreseen, for example, in our EU agreements, is that as a matter of principle, the content of the mediation procedure is confidential, but we ensure that the fact that mediation is taking place, that this can be made public, and we also state that any mutually agreed solution should be made publicly available at the end, subject, of course, to the reduction of protected or confidential information. But we believe that we need to find the right balance here between these competing objectives of having a trustful environment where solutions can be found among the parties, but also the really legitimate request by the public to know what has been agreed in the end between the state and the foreign investor. And I think here we may have been actually pushing a bit beyond what is the case in the existing mediation rules, in particular with the mandatory publication of the mutually agreed solutions, and we have to see how this works in practice. But we think it's very important. I mean, we're coming from a background of policy debate about ISDS reform, and this aspect of transparency for us is also very important throughout all the different forms of investment dispute settlement.
And I think you're picking up a really good point there, André. That is an aspect to find the balance, confidentiality and disclosure of information. And there also in the context of each state and what are the domestic legislation on that, on public-private partnership, on concession agreements, what information goes out, when, how much information goes out. In the context of a settlement agreement, public financial regulation, budgetary transparency regulation, all of these domestic legislation that require a state to publish information, very general, not specific to ISDS. And that is, I think, a thing that within the mediations, it's important for state official especially, but also for the investor to keep in mind what is the applicable domestic framework in that context as well. And then certainly you can regulate that on the treaty level. Dyalá, what do you think about challenges to investment mediation and how could these be addressed?
Yes, I think actually going to the question of confidentiality, I believe there's a question from Herman Verbis regarding what can be communicated. So I will take it from there, and André, and your comments. One of the challenges is indeed accountability. If public officials are accountable, and every year as a minister you go to Congress, at least in my system and in other countries, to defend your budget and to defend why you're spending X amount of dollars or euros or whatever currency on investment arbitration cases. We have quite some arbitration cases, so we needed to do that, especially because it was a big percentage of the budget of the ministry. So one challenge is accountability, how much you need to inform. From what you were saying, Frauke, how much does the legal framework require you to inform? And the other hand, how much does the process need confidentiality in order to work? And to answer Herman Verbis' question, we always explain to the press how we need, how part of our obligation was to protect the process. So when you really convey and you have credibility to the media and to the public that you need to keep some things from the public for the time being at least, and you do it well and you substantiate it as something that is your obligation as a public functionary, you can really do a good job in really safeguarding the information. So I think not only is the legal framework important, but also how you as a public official do about to convey that. Number two, challenges. I think that reliability. Public officials need to have some kind of legal protection in a way that they will not be liable personally for the settlement of a dispute. Now, that, of course, has limits, the criminal limits, corruption, and all sorts of limits. But you need, as a public official, to have some kind of leeway and a public authorization or legal authorization to enter into settlements. Number three, I think you need to have coordination, because the stakeholders within the government can be varied and can have different and sometimes conflicting agendas and interests. So you need a body that coordinates. In Costa Rica, we do have it. I believe other countries have such bodies, and we have an interministerial body that is led by the Ministry of the Presidency is called in Costa Rica. And so we have a very thought out group or body that really coordinates this, and you have collective decisions. And number four, I would say training. And we already spoke about that. We need really to understand internally in the government how to go about the mediation. We also need training to enter into negotiations with the private sector. That's a whole other area, but you need, in general, you need public officials to know how about to go with mediation, which is different. And maybe the last one is we need good mediators that speak the language of the parties involved and that can be trustworthy, and all that part that is more procedural, and maybe we can talk about that later.
Thank you. Yeah. Thank you. You brought up a number of really interesting points, and thanks for sharing sort of your practical experience there, because especially on the state perspective, right? You may have entities that are involved in the dispute that may not be the same as those that you need to find a resolution. And then you may have actually a mediation within the mediation on the part of the different entities and their interests, with a layover of the political considerations. That may sometimes, I've heard, is not only applicable to states, but maybe happening on the investor side too, with the parent company or different structures, company structures that they have. Okay, one more question before we turn over to Diana, who has been waiting patiently for her turn to talk about more practical aspects of actual mediations being conducted. Andre, you started out with sharing with us about the provisions in the EU investment agreements on the relationship between arbitration and mediation, and to regulate some aspects of that procedure and relationship. How do you see that relationship between mediation and arbitration?
Yes, I think that's the quite complex question, and you can see it from different angles. I think, first of all, we normally see mediation and litigation as alternative and complementary ways of resolving disputes. So I don't think that they should be mutually exclusive. If there was a sort of fork in the road provision, I think then the investors may be less inclined to go to mediation if they would lose the right to go to litigation in case the mediation is not successful. We have also not gone so far as to make mediation mandatory before it is possible to go to litigation, because we think there may be situations where the relations between the investor and the state are simply so bad that it is simply not useful to try to go to mediation in these situations. But what we do in our EU agreements is to try to encourage as much as possible recourse to mediation without, however, making it mandatory, and also by making clear that if you go to mediation, you can still go to dispute settlement if you don't have a satisfactory outcome in the mediation procedure. And so, for example, in all our treaties, you will find language saying that the recourse to mediation is without prejudice to the rights of the parties under this agreement in the dispute settlement chapters. And we also, most importantly, what we do, we say that if the disputing parties decide to go to mediation, then the timelines for submitting a claim under the dispute settlement chapters are suspended, so that we don't get into a situation where a party would be reluctant to try mediation by fear that it will then miss some timelines to go to litigation. So I think this is a quite important point to really encourage the recourse to mediation. This being said, I mean, if the parties agree to go to mediation, there may also be some good reasons for them to agree that no claim should be submitted during the mediation, or that if there's a mutually agreed solution that has been found, that the measure should not be subject to a subsequent ISDS claim. And this is something that can, of course, be done by the disputing parties, either at the beginning of the procedure, for example, in a kind of mediation conference, management conference at the beginning, or even as part of a mutually agreed solution. The parties could agree that there should be no litigation with regard to this measure. And we have some kind of those provision in some of our recent treaties, in particular the Investment Protection Agreement between the EU and Vietnam has some more detailed provisions on this. If, on the other hand, there were already a claim pending, and then the parties go to mediation, this is also possible under our agreement. We always say you can resort to mediation at any time, even if a claim is pending. Then also the parties may want to agree to ask the tribunal to suspend the pending claim during the mediation. It's also something that the possibility that we have foreseen in a number of agreements, for example, with Vietnam. But I think there may also be a situation in which, for example, the parties may not want to suspend the proceedings and have both in parallel. I think here it really will depend on the characteristics of each individual situation and case. And for now, we've tried to give quite some flexibility here to the disputing parties on how to address these parallel situations. But as I said, to sum up, as I said at the beginning, there should be complementary, alternative, but not strictly exclusive in our point of view.
Thank you, André. And I think it's really important to pause here and to see that how you have comprehensively addressed the mediation option at different times in the dispute settlement procedure envisioned under the treaty, and we are moving away from the old clauses that say ICSID, arbitration or conciliation, right? We are much more specific in your treaties of one doesn't exclude the other, and to give favorable consideration for a request, and then certainly with that timeline. Dyalá, do you have a sentence or two, if I may introduce that question to you with that time frame? So we move on to Diana. Do you have thoughts on the relationship that you'd like to add?
I do, very briefly, because I'm aware of the time. Thank you, Frauke. Just, I think conceptually or in theory, it would be good for the arbitrators to ask the parties to go to mediation, because from the state and SOE perspective, this is very useful to have the arbitrators suggest it, and that can really mean something in terms of accountability. This is very difficult in practice because arbitrators, we are not trained for that, and we feel that our role is not that. So I'm not speaking as an arbitrator, I'm speaking from the state point of view. This is something I wanted to add to the mix. Thank you.
We've heard that. And thank you for bringing that point up, sort of the initiation to come externally. And interestingly, on the national level, the AAA, for example, has now mandatory mediation built into their arbitration. It's no longer an opt-in, it's an opt-out. So Diana, now over to you. So you are counsel in investment arbitration, but you have also represented parties in investment mediation that have happened. So could you share a bit with us insights on the practical view on how our counsel preparing for a mediation? How do you prepare for a written statement or for a meeting? Maybe you can give us some insights and point to the differences to how it is from arbitration.
Yeah, thank you very much, Frauke. Thank you to all. Thank you to ICSID. I learned a lot listening to the three of you. So I will just add some practical aspects to this practice. So yes, I've actually participated as a counsel in matters that have in investment disputes that have actually settled through mediation. And yes, the role of a counsel in that context is very different indeed. It is a different approach to representation. First, as a counsel in investment in mediation, you do not adopt the traditional adversarial strategy where you present your strongest argument and you attack the other side's arguments, where you try to actually convince the arbitrator that your client is right. In a mediation process, there is no decision maker. So you do not have to try to convince the neutral of anything. And actually, the party that you have to convince is the other side. And in that context, the adversarial approach is counterproductive. And what you have to advocate not as an adversary, but much more as, I would say, as a problem solver. And your goal is to help your client find a solution that actually meets most, if not all, of its interest. But you cannot do it alone. You have to also embark the other side and make sure that the solution that you're building in, that you're proposing, because you have to really think a little bit outside of the box, knowing that the solution that can be proposed can be solutions that are not necessarily limited, to financial damages, but potentially other solutions as well, meet the interests of the other side as well. So it requires quite a bit of, I would say, of empathy, both on the client side and mostly on the counsel as well, to make sure that your client understands the other side's point of view, positions at first, and most importantly, interest. And then I just want to, if you allow me, Frake, just to address a very common misunderstanding, which would be to think that an attorney has no role in mediation. And that an attorney would have only a real role or a central role only in arbitration. Because you hear oftentimes that mediation is a thing of the parties, that mediation is only a negotiation that is assisted by a third party neutral. The reality is that there is a dispute, and as André and Dyalá actually highlighted, there is a need to preserve the rights of the client. You need to make sure that the process actually addresses the procedural needs of your client, and that's a key role for an attorney. And most importantly, of course, find the best solution again for the existing dispute. And the attorney has a role throughout the process, from assessing the best dispute resolution tool, because I have, for example, a very holistic view of dispute resolution, and I like to put mediation as part of ADR, but not seen as an alternative to arbitration, but more seen as an, one appropriate mean when it is appropriate. It's not always the appropriate, as Andrea said, it's not always the appropriate resolution tool. So first, the attorney needs to assess whether or not mediation is the appropriate tool to solve a particular dispute. Then you have to choose a mediator. This point was also addressed. Then you have to negotiate the best mediation protocol. Then you have to prepare for the pre-mediation conference. You have to draft the submissions. You have to prepare the negotiation, the BATNA, the WATNA, all these reason negotiation terms have to be actually prepared with the help of the attorney. So and of course, I'm not even mentioning the drafting of the settlement agreement, etc., etc. So the role of the attorney in the entire process, which is not always, it might not be as long as an arbitration process, it still requires a lot of work.
Yeah, thank you for sharing that insight, and to see the shift of the mindset, right? Not the adversarial approach, but to look at solutions, look at interest, but potentially helping the client to work through the interest and the goals that they wish to achieve through the amicable settlement process. And so if you look at, you mentioned towards the end, just submissions. So are submissions in mediation 300 pages?
No, usually we try to make those submissions much shorter. You need to think and keep in mind what is the goal of your submission. And of course, you want to include classical elements such as, chronology of events, what are the critical legal issues, what are the relief that you are actually seeking. But you also want to include some bridges. Okay, so you have to ask yourself, what do I need in order to have this dispute solved? And for that, you need to have identified what are or where or are the impediment to the resolution of your dispute through settlement. And that sometimes is, a lack of fluid communication. It can be a lack of information, unequal information on both sides. And in that case, if that's the impediment, you want to include in the mediation procedure an exchange of document, or you want to make sure that these documents will be produced. So you can express in your submission the need to address that impediment. You also, if you want to start building a bridge, you want to also express what is the interest of your client. And then explain clearly what you want out of mediation. Because in your written statement, you want to keep in mind that you need to create a genuine atmosphere of cooperation. So you don't want, again, to be adversarial and just say, I'm right on everything. It's not that you're going to admit or not be tough on your position, which will be expressed, but you need to keep doors open and make sure that the other side start trusting you, because without trust, and the mediator will help in that process, but without trust, there will not be any settlement.
Yeah. You need that cooperation and willingness to continue to engage with each other on the level of trust. And you identified that you can have, and that is, I think, often also a misunderstanding. You can be tough, as you say, on your position and on what you would tend to achieve while working from a different angle towards a resolution. So you mentioned mediator skills, and I know you are an experienced mediator. What are, in the context of investment mediation, what is essential mediator skills in your view?
Well, in my view, you need the mediator needs to know how a state actually functions, because oftentimes I noticed that what tend to stiffen a little bit the investor is sometimes the slow responses from the state, because the investors do not understand how a state actually works. And what you want is to have a mediator who understands how states work, so as to convey and explain on the other side that it might not be a showing of bad faith from the state, but that the state, the different agencies, ministries need to obtain certain green lights and go through certain processes. And so I think a knowledge of state functioning on the part of a mediator is actually pretty key. Now, of course, those mediation in investment dispute are international. So you also need to have a mediator who has an intercultural understanding. Mediation is actually practiced very differently. If you take, an English mediator, there will be a lot of caucuses, much less plenary session. If you take a French mediator, you will have almost only plenary sessions. If you take, an American mediator from the east side or the west side, it won't be the same thing. So you need to meet the expectation of the parties, and to that extent, you need the mediator need to be flexible and understand where the parties come from. He also needs intraculturally to understand, how culturally each party communicate with, this classical expression of, parties being lost in translation. But it's the reality. We often see that misunderstanding come from just the parties not understanding the cues or the communication of either side. So that's very important. I think the mediator needs to be also trained, and then the mediator will need to have all the other skills of a very good mediator, meaning, empathy, good grasp of investment disputes, and and this ability, this high level of energy. Because I think that in investment disputes, it's in all mediation usually it's pretty tough, but I think in investment mediation in particular, you need a mediator who has a lot of tenacity to push the process forward.
Yeah, thank you. And the cultural aspect that you brought up, not only in terms of location throughout the world, culture as regional or linked to countries, but also institutional cultures of government. That's what you bring out. And Dyalá had mentioned that earlier. We need to speak the same language. You need to be able to convey and reach your audience. So what are challenges that you have seen in your practice of engaging parties in mediation? We heard sort of an abstract policy aspect of it, and on the ground, what have you seen and how can these be addressed either as a representative or as a mediator?
Well, I think both André and Dyalá have actually identified challenges that we see on the ground. That of parties not wanting to take responsibility for decision making and preferring, to have an arbitrator decide is something that I see as a major obstacle to the development of this practice in mediation in investment dispute. Also the fear of public criticism, the fear, and I had a conference call not that long ago, in one of my cases, and there is clearly the fear of suspicion of corruption, also the conflict of different stakeholders in state ministries, agencies, they have conflicting or competing interests. Who will actually participate in the mediation? That's very practical, but who will participate in the mediation? Who will dictate the strategy? What is an acceptable result? How far can we go? Do we have a mandate to go as far as we want to go? All these questions are actually very, very practical. It's also another very practical consideration is it's difficult for states to obtain a budget for settling, as opposed to obtaining a sum when there is an award to be paid. That's very practical, and I see it as part of the discussion that I have with my client. And
as a mediator or as a counsel, you can help the parties work through that process and give them some guidance. Is that right?
Yes, but it's part of this effort of raising awareness as well. So I'm their counsel, and I can say a lot. But I had a conversation. I remember clearly a few months ago with a client. I actually cited to your works and to these these general common efforts to embrace mediation as a tool for dispute resolution, because it's kind of an ecosystem that is being created that helps legitimize as well, the advice that we're giving, saying, well, look, it's something that is being encouraged throughout. So that's very important, continuing to raise awareness, and the training that you're offering to government officials. I refer to that as well. Now, on the council side, there is a lot of reality checking, a very fluid communication back and forth, but very genuine discussion with the client as to, why mediation is the right dispute resolution tool for that particular case. What we have to avoid absolutely is generalities. But we have to be very reassuring, and the way we can reassure sometimes, or we manage to reassure our clients, is by setting up very clear procedures and be very, very transparent as to what are the different procedural options to meet their procedural interest. When they say, well, we have concerns about political, or public criticism, then we have to explain, okay, well, we can we can maybe put in place or include, some joint press release that will be negotiated in the framework of the mediation, for example. All these kind of things. We need to address their concern one by one.
Thank you. Thanks for sharing that, Diana. And you picked up on that was in addition to the question that we had in the chat earlier about the communication, joint press releases at different stages of the mediations agreed by the parties to provide information and about what is actually going on in the mediation is another tool. And just one observation here, we are talking about the difficulties and the challenges and aspects about how these can be overcome. But we know from ICSID statistics of actually the arbitrations that are being conducted that we have 30 to 40% settlement rate. So settlement mediation is not completely new in terms of the desired outcome. It's just a different way of getting there. With that, I have a concluding question to all three of you. What, in your view, are sort of the areas of focus for the future of investment mediation? Mindful we have quite a few already. I am aware of at least 30 that happened. Diana certainly is part of the groundwork that is ongoing. But what, in your view, to all three of you, are areas that we need to focus on to further advance mediation? And Dyalá, why don't we start with you?
Sure, I think 3 areas. The first, to get more states sign or join the Singapore Convention. Number 2, to get legal frameworks locally that are apt in order to make public officials feel protected and encouraged, but also to make the process work in terms of the question by Andreas Hake, for example, how to be sure, and what Diana was saying, how to make sure that the participants in the mediation have the authority or the representation. And so I would say Singapore Convention, national legal frameworks, or not only legal frameworks, but the whole legal maybe policies. And number 3, training as always.
Thank you. André, over to you. Concluding thoughts?
Well, I pretty much agree with what has been said by Dyalá. I think what is important really is maybe advice really for governments how to organize themselves to really conduct successfully mediation procedures. And here I'm talking from a regional economic integration organization, which is even more complex than a national government. So I think this is a point where really advice also from international institutions is welcome, but also to raise awareness among investors, I think in particular SMEs, that this is a viable option and this should be more explored in the future.
Thank you, André. Diana, your thoughts?
No, I agree with everything that Dyalá and André just said. I think that what we need to do is really convey the message that mediation actually is is one tool among others to resolve investment dispute. But with its adoption and its use, the entire dispute resolution system as a whole becomes much more sustainable. For me, we are building a more sustainable investment dispute ecosystem, and to that extent, in my mind, it increases the legitimacy of investor-state dispute settlement as a whole. So everybody has to benefit from the development of mediation in matter of investments.
Thank you. Thank you to all three. It's been a pleasure and an honor to have you here to discuss policy and practice in investment mediation. And that concludes our episode, our 5th episode. And I look forward to welcoming you on January 26, 2 weeks from now, same time, where we will have our final episode when we talk to 3 experienced mediators who have mediated investment disputes. And until then, be well and be safe, and we'll see you soon again. Thank you.